Our next question is from Greg via text message, and he asks us, can I set up a trust that incentivizes my heirs to make responsible financial decisions? Greg, the quick answer to that is absolutely. That's one of the main reasons people choose to create a trust. The other is to bypass probate and not have the cost and the public nature of your estate being out there and having to pay the government to go through the probate process. But let's talk about the reasons you would how a trust works, John, so that you can incentivize your heirs to make responsible financial decisions.
So, Scott, a trust is essentially a legal entity. It is almost like a company. It is your own personal legal entity that you put your assets into in the name of the trust so that when you pass away, certain things can be done according to the trust language. And who controls the trust language? Well, you do through your attorney that structures that trust to be basically distributed out to your heirs, whoever it is that you want to receive those funds. So your question really turned on, what about making sound financial decisions or quality financial decisions with that money? Oftentimes we see when a beneficiary receives an IRA or a 401k or a life insurance policy, it is happy days are here again. It is like the piggy bank has been broken out and we go get new cars, we go get new houses, we go get all this stuff, and mom and dad would have sure wanted us to do that. Well, what mom and dad probably want you to do is to make smart financial decisions with this money and use it to your long-term benefit, not short-term gratification. So when you set up a trust, that trust actually acts as a tool that distributes money to your heirs according to the language that is in the trust. Now, who does that? A trustee is the person that actually does that. So if you feel like you have financially responsible children, then you can name one of the children as the trustee of that trust, and they can administer that trust according to the terms of the trust. Now, if they don't do that for whatever reason, then the other children can take them to task, maybe even bring a lawsuit if they are not fulfilling their fiduciary responsibility in the trust. You have to be able to look at that trust and say, okay, am I going by in accordance to what this trust says? And you have a legal responsibility to do that if you're a trustee. Now, there are corporate trustees. If you say, my kids are going to fight, I don't want that, or nobody's responsible to really administer this, then there's a corporate trustee. Banks do this in their trust department all the time. They become the corporate trustee of your trust, and then they administer that as a third party according to the terms of the trust. And so that's how a trust generally works. And there's a lot of ifs, ands, and buts that you can throw into a trust to say, I want this money distributed in this particular way, in this particular fashion, over this particular amount of time. Where you run into a little bit of a challenge, Scott, is in the conflict with the IRA regulations, the Secure Act, as it's called, that actually forces the distribution of IRA assets and any other type of qualified asset out of that trust within a 10-year period of time.
Yeah, so just to kind of reiterate what you're saying, for Greg and anybody else interested in this, if you have beneficiaries of any retirement account, and it is the next generation, 10 years or more younger than you upon your passing, and typically upon your passing, if you're married, it's going to go to your spouse, so it doesn't apply to the spouse, but once the second spouse has passed away and it goes to the next generation, the rule now states that the inherited IRA dollars must be completely withdrawn over a 10-year period, and that does supersede any language written into the trust. So just know that you still could put some regulators on that, right? Because the happy days are here again would be prolonged at least over 10 years instead of 10 days, but it does have to come out over the 10 years. And another thing to keep in mind here too is you have to fully fund the trust. A lot of people are good at creating trust, but they don't put the things in place to fully fund the trust. Some of your assets you may want the trust to own while you're alive, like your home, other real estate, maybe even bank accounts. But some assets you may want to only fund the trust with the assets after your death. And I think about, too, you talk about incentivizing your kids. Another piece of this, too, is A lot of times the IRAs and the other investment accounts are pretty simple. You're just going to divide those up pro rata and the kids get them. But there are some special items, some things that you may want your son to have the guns, or maybe it's your daughter to have the guns. I don't know. But if you have special items like that, guns, jewelry, special things like that, you can identify which of your children gets those, and that can be talked about while you're still living.
Yeah, and there's all kinds of caveats in trust that can be created where if you say, okay, well, I want to be sure that if I leave this particular asset to my spouse in a blended family type situation, that the money passes on down to the decedent's children from the spouse in that particular account or whatever the case may be. There's a lot of caveats that you can put into a trust, and that's why you would sit down with an attorney to walk through that and deal with the complexities of a particular trust. Most of the time, though, you can do a trust, and it's fairly simple. It's fairly straightforward, and there are ways that you can do that at less cost than actually sitting down with an attorney. So there's a lot of difference there that you can take a look at and try to create something that gives you the opportunity to control that money and incent your children to be financially responsible with whatever it is that you have left them in the bequest.